Mr. Cooksall, you've circulated a proposed summons seeking a recusal, protective costs and a stay.
Yes.
So what are you proposing be done in relation to those matters?
So in relation to the recusal, we are saying that on the basis of the grounds identified in the affidavit of Ms. Zhu, including the fact that when
Mr. Cooksall, I can tell you, I'm not going to go now and stop down and read an affidavit. I've just received a notice from my associates that an affidavit has just been received. So I'm not going to stop and look at that now. Just tell me what it is you are proposing procedurally in terms of indistinct.
Procedurally, we're saying that the court is in effect, or Your Honor is in effect, disqualified from association with.
Mr. Cooksall, please answer my question. I don't want your argument. I want to know what you are proposing point of view to move this matter forward.
All right. No, I understand now. Thank you. Sure. So in our view, what should happen is a different judge should hear firstly our application that the current proceeding is an abuse of the court process because again, this is.
Okay, now, what is your application that the current proceeding is an abuse of the court process?
So, Your Honor, because they are seeking to maintain an injunction.
No, simple point, you haven't sent any summons, I don't think you've made an application. Are you seeking an order that I should find that this proceeding is an abusive process?
Yes.
How are you making that application? Have you filed a summons or sought to file a summons?
We can file the summons, but we don't need to because apparently what is happening is they are seeking to maintain an injunction.
Yes.
When the basis of the injunction is no longer in existence.
All right, so, procedurally, you have an application to say that it's an abusive process.
It's an abusive process and we will further allege.
Okay, and what relief do you say that gives rises to?
Well, firstly, the court should dismiss the application because, or the proceeding, sorry.
Yes.
Because they have not identified, this proceeding is brought on the basis of S447 of the Uniform Law.
Mr. Cooksall, I don't want your argument, I am just trying to work out what's happening procedurally.
Yes, so, the proceeding needs to be dismissed.
One is you want to make an application that the matter be dismissed on the grounds that it's an abusive process.
Proceeding be dismissed, yes.
The proceeding be dismissed on the grounds of abusive process.
Yes, Your Honor, that's right.
What other applications do you want to make?
We will make an application for our costs in relation to.
No, okay, but if you get the proceeding stayed as an abusive process, the costs.
Just let's, sorry.
Dismissed. All right, so one issue then is the proceedings an abusive process. What other issues are you wishing to raise?
In relation to the proceeding?
No, I am going to be having to deal with how to move this matter forward. Now, for example, the draft summons or the proposed summons talked about a protective costs order.
Yes, that's right.
Are you seeking a protective costs order?
Yes, but what we would, in the interest of efficiency, I think the court should hear the argument about the abusive process first.
I will come to the order of things first. I am just trying to write down a list of issues that the parties are seeking to raise.
Because the other issues would no longer need to be decided.
Yes, so there's the abusive process question, there's the protective costs order question.
And there are subpoenas.
And there are subpoenas.
And we also note that.
Subpoenas and the recusal.
Sorry.
And the recusal.
The recusal is the first issue, yes. And then the subpoenas. Now, Your Honor, we also note that the plaintiff has not filed a Form 4A and Form 4B, the overarching obligations matters, and we will also be making an application in relation to the disclosure obligations that the plaintiff has in the proceedings, and we will rely on the.
Tell me what the application, tell me what, so far.
We can identify documents to the court.
Just go back. So far I've got 4 things. Dismissal for abusive process, putting order to one side and I know that they might be in the alternative or not be necessary and so forth. There is an abusive process application, a protective costs order application, a subpoena application and a recusal application.
Subpoenas, plural.
Subpoenas and a recusal application. Are you saying there's anything else?
Yes, there'll also be an application in relation to the breach of overarching obligations in relation to the improper non-disclosure or suppression of material and in relation to the steps taken in these proceedings which were entirely without merit.
Okay, so breach of overarching obligations re-material. You say what relief does that give rise to?
So there's a wide range of relief, but that.
What would you be seeking?
We would be seeking costs in relation to damages and loss, so not costs as in the legal costs but the non-input by different parties on account of the improper conduct, and we will be seeking determinations against Legal Services Board.
Right, now, how long, if one comes to the substance of the dispute, in terms of getting your affidavit material ready for the substantive issues, putting to one side the cost orders and the recusal application, the abusive process and the breach of overarching obligations? If the board was to give you the material on which it seeks to rely by the 21st of June, how long will you take to get your material in response?
So, Your Honor, we are awaiting the decision in respect of a number of subpoenas and other administrative applications that we filed. In the next 3 or 4 weeks they will mature or they will conclude.
These applications, sorry, what are they?
So, there's an application that we have currently with the Office of the Australian Information Commissioner in relation to disclosure of material. They have ruled in our favour, but they want to give the other sides 4 weeks to appeal the decision. The VLSB is implicated in improper conduct based on the material that we will.
Right.
So, we wish to lodge that, we wish to rely on that material, so that will be available to us in 4 weeks exactly, presuming the tribunal application doesn't go the way of the opponents. But currently we have an entitlement to get that material. So we would say, in terms of procedural orders, we would seek another 2 weeks after they have filed the material.
What I was thinking, if they've said they can get it in by the 21st of June, if you had to the 12th of July?
Yes, that should be sufficient, but if there is some delay in the release of documents, then we will
cross that bridge when we come to it.
Yes.
Now, Mr. Cooksall, can you identify for me now what the forensic purpose of the proposed subpoenas to Fiona Macleay, the Victorian Legal Service Commissioner and the Chief Commissioner of Police, Shane Patton?
So, it's my understanding that Your Honour has already approved the subpoenas.
No, I have not in this proceeding. I have given no leave to file any subpoenas.
But it would be inconsistent with the other decision if we were not given leave.
This is your opportunity, Mr. Cooksall, to identify for me a forensic purpose for which you seek to have these subpoenas filed and served in this proceeding.
Okay.
It concerns whether an injunction should be made to prevent you representing yourself as associated with.
Yes, Your Honour, I have to say this because otherwise I am forfeiting the opportunity to say it. The court should not be asking me what the legitimate forensic purpose is at this stage. The only thing that the court has to consider is whether there will be an obvious abuse of process if the subpoena was issued such that there would be unfair prejudice, which would be so unfair as to stop me from invoking the court's jurisdiction preemptively.
Okay, I have made a note that your position is that I don't really have any discretion on the matter. I should issue it and it should be up to
them to take objection.
Make application.
Yes, so then we have to identify the legitimate forensic purpose.
Okay.
But I will advise the court anyway. I have to take that point because as a matter of law if I don't.
You're protecting yourself from an appeal if need be. I understand.
Yes, that's right. So now the legitimate forensic purpose is very straightforward, Your Honour. The documents that we're seeking from firstly the LSB was required to provide to us. By the operation of the uniform law they are required to provide to us with all of the complaints that they've received against us and give us an opportunity to address them on that. They have not provided us with any of the complaints. We don't even know what kind of complaints they've received in totality.
Why does that matter in this case? This case is concerning really whether you don't have as I understand it this is the common ground. That you were the alternate beneficial owner of People Shop Pty Limited.
I'm the sole shareholder. Yes.
Yes, and you have neither legal qualifications nor a practicing certificate.
Yes, but I don't need to have those too.
I understand that. Ms. Zhu was a director of People Shop. Is that right?
She was at one point. Yes.
At one point, yes. And Mr. Ansell has legal qualifications, certainly had a practicing certificate.
We say he still does.
The board didn't renew it or whatever, and you challenge that its failure to renew it or its conduct in relation to wasn't effective.
Exactly. We're saying that in effect, as a matter of law, Mr. Ansell does have a practicing certificate because the purported non-renewal of the certificate is pursuant to a conspiracy that the Legal Services Board has engaged in, of which there is overwhelming evidence, some of which has been exhibited to the affidavit filed this morning. There have been determinations made in respect of the viability of that argument.
I understand the point, I think.
So the purpose of the subpoena is,
in terms of the paperwork that exists, Mr. Ansell does not currently have a practicing certificate, and it's your contention that it was improper conduct on the part of the board not to renew it.
Well, there is no paperwork for anybody. No paper certificates are ever issued now. It's just a record, and we're saying that they have corrupted the record. They have adulterated the record.
So you're accepting that the record at the moment is such that Mr. Ansell does not have a practicing certificate, and you say that the board has improperly failed to renew his practicing certificate.
No, what we're saying is that the board, in the notion of the abstract statutory entity, has issued the certificate to Mr. Ansell, and then the people that are acting maliciously or corruptly are preventing that record from being discovered to the public.
But wasn't it a situation where it has to be renewed?
Yes.
The practicing certificate that was issued initially expired.
No.
And the question was whether it should be renewed.
No, Your Honor. So on the 31st of July 2022, Mr. Ansell's practicing certificate was extended, and then on the 18th of October 2022 the LSB advised him, sorry, on the 1st of July, not the 31st of July, the LSB advised him that the practicing certificate, which was presumed to be extended on the 1st of July, has been retroactively cancelled. So he had been practicing that year, and on the 18th of October it abruptly told him that it had retroactively, in effect, revoked his practicing certificate. The other fact, Your Honor, is that the non-renewal of someone's practicing certificate is not the proper means to stop them from practicing as a lawyer. They must apply to the Supreme Court to have Mr. Ansell's name struck off the roll. The reason why they have not done so, and that is why this proceeding is an abuse of process, what they're trying to achieve through this proceeding.
I understand that. So your argument is that
there is no proper basis for it.
Yes.
So what they're trying to do is maintain a position, and in our view it's because in this proceeding Your Honor has made a number of decisions which are contrary to the law, and therefore they're trying to improperly benefit and maintain their position. But in every other proceeding, Your Honor, the LSB has been condemned for their unlawful conduct, even in the magistrates' court where I had very strong disagreements with the magistrates. No one has been able to deny the improper conduct that the LSB has engaged in relation to interference in my legal representation.
So, can I ask you, Mr. Ansell, do you assert, Mr. Ansell, that you at the moment are legally entitled to engage in legal practice?
Yes, Your Honor, and one of the arguments I raise, Your Honor, is there's no presumption of indistinct in the decision of lower tribunals, which is really the basis of our application in the other matter.
All right, Mr. Cooksall, thanks for that. So the forensic purpose of the subpoenas is to
establish the conspiracy.
Allow you to establish that the conspiracy which
pursuant to which
the conspiracy which invalidates in a sense any step taken to.
Yes, because that is the motive. We say that the objective of that conspiracy is the reason why Mr. Ansell's entitlement to practice has been unlawfully interfered with.
All right, well, I'll reflect on that. Anything else you need to say on the subpoena point?
Your Honor, so normally what happens is the other side takes objections.
I'm going to reflect on it and try and get an answer back to you today.
Yes, but what I'm saying is, Your Honor, normally the position to defend the subpoena requires a specific objection to which one responds.
I understand that. All right.
And the other point that I would like to emphasize, Your Honor, is that the court also does not have the discretion to determine that a finitely defined subpoena is oppressive, because oppression fundamentally involves an evaluation of the cost to the party versus the benefit to the administration of justice, and whether those costs are too exorbitant in relation to the benefit of the administration of justice. It's a balancing process. Now, until the party, if the subpoena were completely open and indistinct in the sense that it was ostensibly capable of generating an infinite number of documents, then of course the court would say that this would be oppressive because the other party could never collect and bring those documents. But so long as the documents are finitely defined, the court has no position even if the documents are vaguely defined. Because the law clarifies that the oppression is in relation to the recipient's understanding of the documents. So for instance, if one were to subpoena a medical institute and the manner in which the documents were defined was weighed in relation to the general understanding of regular people and the court, but the language was such that a medical institute could understand because of its technical expertise what was asked, even if it was not asked in the proper jargon, then it will not be an oppressive subpoena. So oppression is fundamentally determined.
I understand that point. I think I understand what you've submitted.
On the last occasion, Your Honor had said that the first version of the subpoena to Mr. Patton was oppressive.
Yes.
And that's why we are preemptively saying that the oppression ground does not arise until the party to whom the subpoena is addressed swears an affidavit and identifies the basis of oppression. I can cite authority for this. It's, just bear with me, Your Honor, the leading authority on this is R.V. Eastman, number 14, 2017, ACTSC.
ACTSC.
Supreme Court of ACT.
Yes, 2017.
66 is the number.
66. Have you got a paragraph in particular, or I just look at the whole thing?
I can.
Is it a long judgment? Is it hundreds of pages or a short judgment?
It's a 13-page judgment.
Don't worry, I'll look at the whole thing, all right.
So what happened in this case, Your Honor, was that the person who was connected with the Italian mafia had subpoenaed all the police forces in Australia of the various states, and then the court had basically gone through the various oppression-related affidavits that different police forces had filed and commented on the manner in which the decisions in respect of oppression ought to be made. There is also another important decision of this court. It is Lambrou v. Smith and Anna, 2019, VSC 254.
254, was it?
254, yes. 2019, And generally the document that I've submitted in relation to the submissions that we rely on or the list of authorities, the paragraphs of authorities that we rely on.
What document are you talking about, Mr. Cooksall?
We have provided the court with an 87-page collection of paragraphs from different authorities with headings on every topic, and that actually is quite an exhaustive collection of the most important authorities on legitimate forensic purpose, fishing expedition, oppression. So, this authority, Lambrew v. Smith, clarifies that the subpoena cannot be a fishing expedition if it already identifies with some particularity the period in which the documents that are sought will exist or would have been created, and the nature of those documents. Because obviously,
Mr. Cooksall, when you say you supplied the court with that document, when and how and in what proceeding?
So, Your Honor, in this proceeding, if Your Honor remembers, Your Honor had given me leave to provide.
Yes, but
In this proceeding, you had given me leave to provide to your chambers. This was the 19th of February to the best of my knowledge or thereabouts, and in this proceeding I have provided the court with the subpoena to Ms. Macleay and Mr. Patton originally, along with a document that contained the list of authorities, pursuant to your.
Well, if it has provided, you say it was emailed to my chambers?
That's right, as per your directions.
All right.
We can resend it, Your Honor, we can resend it, there's no problem in resending it.
All right, so the three essential points again for the subpoenas are, first of all, it's not for me to, I should issue in any event.
Unless
it's, yes.
So if we were subpoenaing the Prime Minister of Fiji, who had no, and we hadn't, and you and the courts have no basis to suspect that we would allege that the LSB was in conspiracy with the Prime Minister of Fiji, then it would be an abuse of process. But it has to be an abuse of process of such magnitude that the court would preemptively abstain from exercising jurisdiction because it would bring the administration of justice into disrepute of its position. The normal position is that even if it is oppressive or the disclosure of documents would other obligations to disclose the documents would ultimately attain an abuse of the court process. It is for the parties who have received subpoenas to make that argument in court, and then the court.
That ties up with your third point on oppression. The oppression is in the.
That's right, oppression is in respect of the inconvenience of costs to the recipient of the subpoena. It's not.
I understand, Mr. Cooksall, I understand those points. I am going to reflect on them. I am going to look at Eastman, number 14, and Lambrew, those cases, around about 87.
Your Honor, we will also resend the list of authorities.
When you mentioned it, it did ring a bell, but I don't have it immediately before me this morning.
We will resend it to Your Honor.
Now, so there's the subpoena issue. Let's turn to the recusal issue. Mr. Cooksall, I have lost count, but you must have made close to 10 recusal applications now?
More than that, Your Honor. I think Your Honor was not paying attention to all of them.
Mr. Cooksall, what has changed?
So, Your Honor, at the last occasion, what Your Honor said in the indistinct application was that even if the defendants had grounds to commence indistinct proceedings against Your Honor on the basis that they had recklessly been errors of the sort that have caused detriment to the plaintiffs in those proceedings and defendants in these proceedings, even then, the court was not necessarily required or the judge was not necessarily required to recuse himself. That, Your Honor, is entirely inconsistent with everything about the law because.
Mr. Cooksall, I asked you what is new.
The change now.
What you're doing now is you're just saying I was wrong not to recuse myself.
No, I'm saying that has compelled us, that and pursuant to that, Your Honor's refusal to issue the subpoena and the LSB's further communication with the court in respect of how they propose the subpoena should be decided has made it clear to us that if we don't immediately take further action, it is foreseeable that these proceedings will cause further oppression to us. And out of a necessity, we have raised a complaint to IBAC in relation to the further misconduct of the LSB, and we have also alleged that Your Honor's improper decisions have enabled the LSB and Ms. Anaz to continue to act unlawfully. That creates two problems because one, we say that the magnitude of things now is certainly of the sort that brings the administration of justice into disrepute, and the second, more practically relevant problem is that we had wanted to add the IBAC to the current proceedings as we had foreshadowed on summons, not the current proceeding necessarily but the one in which were the plaintiffs and the other.
I am just concerned with this proceeding at the moment. So, have you complained about me to IBAC or just said that
We have complained about you.
You have said that I've made errors that have enabled improper conduct by the VLSB, but what have you accused me of before IBAC?
We're saying that you have recklessly or maliciously made decisions and you continue to make decisions, in furtherance of the position that you've taken. That are 1. Providing the LSB and Ms. Anaz with an unlawful advantage. 2. Those decisions are beyond the jurisdiction of the court, and 3. They are causing us oppression and serious detriment, and you're also preventing us from accessing the court in relation to injunctive measures, subpoenas and other things that we would need to litigate and ultimately put an end to the oppression.
Right, so Mr. Cooksall, but what's the answer? You've done that now, but what's the answer to the public policy concern though? That you can't have a situation where a litigant who is dissatisfied with the judicial officer who is hearing their case can get rid of, so to speak, that judicial officer just by making complaints about.
So, Your Honor, that would be that the court find us in contempt for scandalizing the court's affairs.
Would it?
Yes, absolutely, absolutely. Though what we're saying is we're alleging, Your Honor, effectively of criminal conduct. If we're doing it improperly, we should be held in contempt, and in fact we should be charged. I mean, I don't speak for everybody. I think the other two defendants would be less keen on being charged than I am, and I'm not saying that I'm keen. But what I'm saying is that these allegations, if they're made facetiously or without proper basis, are definitely allegations that would require the court to defend its honor through the contempt of court process, and it would be scandalizing the affairs of the court.
But how? I've got nothing to do with the IBAC inquiry. IBAC will do what it chooses to do in relation to your complaint. I can't.
But Your Honor, you cannot have a judge in the matter where the parties are alleging that the judge is acting so recklessly or maliciously such that the harm that they're causing to the litigants is actionable. You cannot have a situation where that was the case, because ultimately it would create such improper controversy that it would scandalize the affairs of the court. Ultimately the court then needs to clarify whether the litigants are delusional.
But how would the court do that, Mr. Cooksall, when?
By listening to our grounds we're raising, now the application that we're raising.
But are you saying this should happen before IBAC investigates? Should the court?
Definitely, absolutely. If the court thinks so, Your Honor, the first consideration in this matter is that everybody in this country is equal, and so are judges, and while judges of superior courts have a presumption of regularity and proper basis in the actions that they make, that presumption is displaced when serious allegations are made, and then the court needs to decide whether the substance of the allegations is proper or not. If the substance of the allegations is improper and then they are of the serious nature that the defendants are raising, then either the defendants are trying to engage in an abuse of the court process by making completely facetious arguments to, get rid of the judge. If the arguments have been made, and again the test there is not whether the argument will ultimately succeed on the balance of probability. It's whether there was any conceivable basis for a sane person to make those arguments in good faith. If there is no proper basis to make those arguments, and if they are being made tactically to pervert the course of justice, then it's a contempt of court. The second category is where the litigants are delusional, either about the facts in the sense that they have completely misinterpreted the facts, or there is a serious problem in the way that they have grasped the law. In that case again the court could dismiss the issue without charging people with contempt, but the court would still need to give specific reasons and address each of the arguments in law and fact that the parties are raising. The problem that we're facing in the current matter is that we don't think that we're being afforded that right, and we moved beyond the point of apprehended bias. Now we're raising an actual bias argument. That requires a proper trial of its own, and then if the court doesn't recuse itself, if the judge, doesn't recuse himself or herself, then the judge is obliged to assess whether the specific facts and the specific legal arguments raised are capable of being raised. If they are capable of being raised, then there's an automatic disqualification that applies in these matters, because what we're saying is that Your Honor is now associated with us and it's a conflict of interest, and I have authorities, Your Honor, which I can send to Your Honor's chambers and the other side. Basically, no man can be a judge in his own, indistinct, and that's one of the most important axioms in relation to the system of justice that we have. So what we're saying is happening now is that we have a judge who, through a number of unfortunate events, has become conflicted on account of the personal implications that may arise if the matter was judged a specific way. And again, Your Honor, the question here is not whether the judge is actually seeing things that way, because it's an objective test. It's an objective test whether or not there's a conflict of interest. When, for instance, a person has shares in a company, maybe on account of their accountant or someone else investing in the company on the judge's behalf, and the judge does not consciously know or remember that they have shares in a company in relation to which they're about to give judgment. It's not that they don't become conflicted because they hadn't consciously thought about the benefit or loss that they could incur. The fact that there is such an investment in itself automatically causes disqualification. So because the test is not.
I understand that point insofar as it
So what we're saying in these proceedings is
relates when a judge has got a pecuniary interest, for example, in the outcome.
No, not just pecuniary, Your Honor.
Well, that's what the shares would indicate.
Yes, but that was just an example.
But your real case now, you're saying, is not that.
No, it is that in the sense that
it's that you're saying that I have demonstrated actual bias.
Yes, so what I'm saying is that there is a ground for an actual bias argument because, for instance, Your Honor, if the court allows us to issue subpoenas, some of those subpoenas may return documents which may help our argument that Your Honor has caused us substantial harm in the erroneous decisions that were made outside of jurisdiction. That will substantiate or that will allow us to claim a greater quantum against Your Honor in the tort law proceeding for which there is proper basis. So what we're saying is that Your Honor is conflicted because in deciding whether or not we should have access to documents or whether we should be allowed to invoke the court's process.
Could I just stop you for a minute there? You haven't commenced proceedings seeking damages from me. At the moment it's.
But we don't have to. The only reason we haven't is because we've.
You just made a submission that the subpoenas will substantiate the level of damages in a court proceeding. I was just clarifying that the extant complaint is the IBAC one.
Yes, but, Your Honor, I had previously given an undertaking in court that I would commence a proceeding, and the only reason why we haven't is because of the current proceeding burden that we have.
Yes.
But it's not because we don't intend, sorry, I'm not speaking for the others, I'm speaking for myself, that I don't intend to, because I think this is an important issue.
No, but can I tell you, if you commence a proceeding, you commence a proceeding.
But what I'm saying is that it's not the proceeding that gives rise to the conflict. It's the.
But Mr. Cooksall, so far the only thing you've identified that has changed is that you have made the IBAC complaint. I'm not saying that that's a trivial change, but that is the development, so to speak.
The other development is that at the last hearing what Your Honor had indicated is that the patent subpoena was not being issued because of the numerousness of the documents that were sought. So we substantially reduced the multitude of documents that were being sought through the subpoena to Mr. Patton. And despite that, Your Honor has not issued the subpoena, and we say that that again is indistinct of the subconscious or conscious difficulty that Your Honor is facing. So what we're saying is that every day or every application in relation to Your Honor we have to expand far more resources, wait much longer, and in effect face oppression when compared with how these processes are supposed to work. And given that we're in a vulnerable position with these proceedings and we've come to the court against an administrative body that we allege is abusing its authority, that the court, instead of being protective, is basically putting us through a much greater burden with, in every step that we are trying to take, which is creating an ongoing unbearable nuisance to us, and it is in effect depleting our resources and will eventually cause permanent harm in the sense of preventing us from seeking relief in a permanent sense. So the other problem we have is that we don't think that Your Honor can actually judge fairly our applications for Ms. Anna's joinder to the LSB proceedings, or permit subpoenas to be issued against her in the current proceeding. She is a critical person or culprit allegedly in relation to the current matter. She has herself affirmed an affidavit stating, which Your Honor has seen, stating that it was on account of her complaint.
Mr. Cooksall, I think with respect, you've started to ramble a little bit you started off in a more focused way.
No, what I'm saying is that the other conflict we have in relation to. Yes, but it's varied across different areas. We think that in relation to Ms. Anaz, Your Honor would not even listen to the applications and has foreclosed those applications. So I'm emphasizing that because the extent of the discrimination that we're facing is different compared with, in the case of Ms. Anaz, compared with, for instance, Ms. Fiona McClay, because Your Honor did issue the subpoena, and it's not for us to speculate as to why that is so, but what we're saying is the way in which Your Honor is seeking to control these proceedings and prevent us from raising arguments against who we say are co-conspirators with the LSB is such that we cannot get a fair hearing in this matter. So at the last hearing, Your Honor had indicated that Your Honor would seek to limit the considerations in this proceeding to whether or not the LSB had made a technical error. We say that even if the court was seeking to do that, it does not prevent and it should not prevent us from getting all the evidence that can form a proper basis to provide some context to the motivation behind the technical, indistinct error. So even if ultimately, in this proceeding, the court did not give us relief against the LSB or the other parties, defensively we should be able to rely on the conspiracy argument because we say that the decisions that are being made for the benefit of that conspiracy. And,
all right, so what's this got to do with can you bring it back to the recusal application?
Because what we say is that Your Honor has completely shut us down from raising the conspiracy arguments because of Your Honor's concern in relation to how we will exploit the evidence that will be discovered and the determinations that will be made. That are contrary to the interests of those people against those people in other proceedings. So what we're saying is the court is so.
Mr. Cooksall, have you got much more to say on the recusal application?
No, but we will rely on the affidavit of Ms. Zhu, which we want to also.
Which affidavit is that, Mr. Cooksall?
The affidavit that was provided this morning.
How long is that affidavit?
It's I think 5 or 6 pages.
All right.
And we've also provided the court with one critical component of an exhibit in that affidavit, which is a reply.
All right. I'll speak to Ms. Zhu about that in a moment. All right. Is that what you want to say on the recusal application? I'm not going to give a decision right now. I'm going to reflect on it. But is that what you want to say on it?
I think I have raised all the points, but I could have.
Thank you, Ms. Zhu.
I needed more time to explain them better, and may I send some authorities to your Honor's chambers?
No, I think you've told me you've sent 87.
That's just about the subpoenas.
Subpoenas. Now, Ms. Zhu.
Sorry, Your Honor, may I? You didn't tell me if I could or couldn't.
Sorry, what are you proposing to do?
I want to send just a list of authorities about the conflict of interest and the...
How many authorities?
May I send a list of 20 authorities?
Well, when are you going to do it?
I can do it today.
No, but how long will it take? I want to get, what I am planning to do is to finish this mention today and then to make my decision this afternoon, after lunch.
Can I send him about 2 o'clock?
No, you can put it in by 11:30.
Well, that depends on when the proceeding ends, Your Honor.
Yes, well, we'll talk about that at the...
1 hour. May I get 1 hour after the...
Yes, I'll give you an hour.
Thank you.
Well, look, let's see how we go. I would have thought we won't be going too much longer with this. Ms. Zhu, what's the affidavit you've put in say?
Yes, Your Honor. Do you have a copy?
No, not now. I'm not going to look at it now. You just tell me what you say it says. What's the...
So basically reiterates what Mr. Kuxel has said, that we believe that Your Honor has not given us a fair opportunity to add it.
What is the affidavit? Is the affidavit a submission or is it evidence?
So I have put some exhibits that has previous affidavits and other material documents that
They're not new material, they're old, it's material that's been relied on previously.
In other
proceedings, not specifically in this proceeding, but they were before Your Honor.
All right, well, we will see. I'll see if I can dig that up, Ms. Zhu. Anything you want to add?
Yes, Your Honor. Can I do actually also seek 3 additional order in this proceeding.
Yes.
So first of all is that in terms of the affidavit that LSB will file, I would like the affidavit to be sworn by Mr. Howard Rapke and Mr. Howard Bowles, and I say that because... So when we had the injunction hearing previously before Justice Forbes stat...
Okay, just tell me how. What power do I have to tell the VLSB who must swear their affidavits?
Can I just very briefly tell the court why I say that?
All right, briefly because...
No, Your Honor, if I...
Mr. Kuxel.
Her English is not great, Your Honor.
No, Mr. Kuxel, you don't act for Ms. Zhu. She is a defendant. She's filed an affidavit and she is telling me about extra orders she wants. Ms. So you want an order that the VLSB's affidavit has to be sworn by Mr. Rapke and Mr. Bowles?
Mr. Howard Bowles and Mr. Howard Rapke.
Yes.
Because in the 2022 hearing, we have argued that the Ben Davidson affidavits is hearsay, and we said that they shouldn't be admissible, and the counsel acting for the LSB said that they have conceded that it is hearsay evidence, and because they argued it is in the interlocutory hearing, so they should be allowed to use it. So now, because we're no longer in injunction setting, so I say that the evidence that was previously filed by Mr. Benjamin Davidson, which says that he was informed by Mr. Rapke and he was informed by Mr. Bowles, all the evidence that he had previously adduced, should be now sworn by these two.
Ms. Zhu, I think what the effect of this is, what I can recall in other matters that you have put the board on notice that you will be objecting or you may well be objecting to any hearsay evidence that is being led, but I don't think I can order them to have. 2. I can't order them to provide certain evidence sworn by a certain person. You've put them on notice that if they don't lead evidence, let me start again. You've put them on notice that you reserve the right to say I shouldn't accept or whoever hears the matter shouldn't accept the affidavit material because it's hearsay.
Yes, I accept that.
What was the second order? You said you had 3 orders.
Yes. So, the second order is that I would want the court to direct, not order, the Legal Services Board to file a new 4A and 4B, because they have amended their originating motion, and they are seeking new orders against the defendants. So
that's the thing that Mr. Kuxel referred to about that's the overarching.
Yes, but I think they should anyway file jail.
I'll ask Mr. McAuliffe about that. Yes, and what's the third thing?
The third thing needs a little bit of context, so I just say give me 2 minutes if that's okay, Salad.
Yes.
So, this is also in my affidavit, it's more of a submission, is in the last parts. The court doesn't have a copy?
No.
Okay, again I'm sorry for that.
No, can I tell you, you can't just email a big affidavit early in the morning for a 9.30 mention. I mean, when this matter was listed for mention at 9.30 I had another case starting at 10.30. That case is not starting at 10.30, so I'm sitting on, but it was intended to be.
Okay.
I'm sorry, But what I've said is of no consequence, but it's difficult to send a lengthy affidavit just on the morning and expect it can be absorbed and dealt with on the run, so to speak. But tell me what it is in this third point you wish to raise or order you wish to.
Yes. So, I will take 2 minutes to explain. So my submission is that the board other than you amended originating motion. They're relying on S 447 of the Uniform Law, and my submission is that Uniform Law 447 cannot be used by its own. So it needs to connect another section of the Uniform Law to say that which section is breached by the defendant. So previously in the originating motion they have identified that S 364 was the section they're relying on, saying that we have contravened 364. This was in their submissions filed on the 12th of October 22, so if I can read S 364, it says that a person must not without reasonable excuse obstruct an internal intervener exercising a function under this law. So previously how they rely on how they use 447 is by relying on S 364. My question, or if I can ask the court to direct the Legal Services Board to tell me or to explain to me what is the new grounds that the new section they're saying that we have contravened or is contravening or is likely to contravene that will invoke 447.
All right, so just look at the originating motion, the amended one. Pursuant to S 4473, all right. So you want to have it made clear what sections of the Uniform Law it said that they allege you breached for the purpose of obtaining the injunction thereafter in the application.
Yes.
All right.
I say that previously it's 364.
Well, yes, but.
Yes, but I want to know
That's been deleted.
Yes.
That's been removed, indistinct, all right. I'll have to ask Mr. McAuliffe about that, but certainly any directions I make, if I make them, will be directing the plaintiff to file affidavit material and then for you to put affidavit in and then for them to put a submission in and for you to put a submission in, so it ought to be the case that I agree with the central point underlying what you've said is that you ought to know before this matter is, in advance of having to put your submission in, at any rate, what exactly it is alleged you have breached.
Yes. So I understand previously was 364. Now I want to know if they're still relying on it, or if there is another section that they have alleged that we breached. Kerdig.
Right, thanks, Mr. Ansell. Is there anything you wish to add?
Your Honor, other than I rely on what Ms. Zhu's affidavit that Your Honor hasn't yet received in this matter, but I had no further orders in which I seek.
All right, Mr. McAuliffe, the first thing I need to find out if your client's position on Mr. Cooksall's application, which, I take, was joined in by Ms. Zhu and Mr. Ansell, that I recuse myself. Does your client have a view on that, leave it to me or oppose it? What's the situation?
Your Honor, I am conscious of the time.
Don't worry about the time for the moment.
I would certainly oppose the application. It appears that what has occurred is an engineering of a basis on which a complaint's been made to the IBAC to therefore substantiate a further recusal application against Your Honor.
Yes.
And,
Your Honor, I want to clarify. When I said I would say, is he saying that on instructions from the LSB or is that?
Mr. Cooksall.
That's a serious allegation, Your Honor.
Let Mr. McAuliffe finish. I've asked, what's your client's position?
To oppose this further recusal application, yes. The matters which are being put, those particularly on the basis of this complaint being made to the IBAC in my submission, does not provide a basis for either apprehended or actual bias.
Yes.
Your Honor, may I clarify if the LSB is accusing us of scandalizing the affairs of the court? It was.
No, Mr. Cooksall, you can't clarify. They're opposing it. They're suggesting that
we engineered.
I don't know if they're, in terms, accusing you of engineering a basis, but
we want it clarified, Your Honor, because it was said in court and we have a right to have that allegation clarified because.
Well, you're concerned about the allegation. You're saying are they alleging that
we're trying to pervert the course of justice by fraudulently fabricating the basis.
By making a complaint for the purpose of supporting your recusal application. Mr.
Your Honor, it's a criminal offense to make false allegations.
Mr. Cooksall, you've spent the morning accusing everyone of all sorts of improper.
Yeah, but I stand by it, Your Honor, and they can seek as much clarification as they want about it.
Mr. McAuliffe, is your client feel the need to contend that this is a deliberate matter, or are you saying that regardless of whether it is or isn't, it shouldn't be allowed? What's the situation?
That's the latter, Your Honor. Regardless of the reasons why, whether it was genuine, Mr. Cooksall identified whether it was an intentional or possibility of the different scenarios, whether it was genuine. He mentioned about some litigants might be delusional. He mentioned a different scenario about whether or not it was an intentional perversion. Regardless of the reason for the complaint, in my submission, it does not provide a basis for the court making a finding of actual or apprehended bias.
All right,
Sorry, Your Honor, may I clarify, is it their position that even if there was a genuine basis and a legitimate basis, so when I say genuine I mean?
No, Mr. Cooksall, their opinion is that even if you genuinely believe that your complaints are valid and properly,
And they are also valid as a matter of law, even then is it their position that even if the complaints were?
Mr. Cooksall, just, what I understand them to be saying is that assuming that you genuinely believe the complaints that you make, that is not a proper reason for me to recuse myself, and that's what I take from it. Mr. McAuliffe, you heard what Ms. Zhu had to say about a couple of things. First of all, you're on notice, your client's on notice that if affidavits are relied on that aren't sworn by the people with direct knowledge of the matters said, then they will be contending that affidavit material should not be relied on.
Yes, my client is on notice, Your Honor.
Right.
Well, Your Honor, we want to cross-examine.
What about the
certifications issue?
The certification under 4A or 4B? I haven't double-checked those sections.
No, I'm not certain. I haven't double-checked them, either. I'm not certain whether new certifications are required, but potentially the easy way to circumvent this is if Your Honor just grants us leave to file any new certifications if necessary, and we'll double-check those rules just.
I don't know if you would need leave to file that. What's been put against you is that you're effectively under an obligation to file it because the nature of, once you have amended for example, you've added an injunction against Mr. Ansell in broader terms that you initially seeking. Look, I'm not going to make a reference to it in other matters, but again, you're on notice about the fact that the suggestion's been made that if you're properly complying, you should put that in.
Yes.
I appreciate that. I assume that this is a bit on the hop for you this morning, but that's to be noted by your client.
Yes, thank you.
And in terms of the sections of the Act that you will be alleging have been breached or that justify the grant of an injunction, at the end of the day, Ms. Zhu has observed that the unamended originating motion referred to S-334, and that's been crossed out, but the allegation was that people were appointed pursuant to S-334. So,
Sorry, Your Honor, it's 364.
364.
That's in their submissions document.
In their submissions, not in the originating motion. Sorry, Ms.
Yeah, but also Ada.
No.
Yep. So
I think you'll have to make it pretty clear in any submission you put in, Mr. McAuliffe, exactly what provisions you're relying on and in what way.
Yes, I accept that, Your Honor. And again, my client and my instructors are on notice. I do note that the amended originating motion, just leaving to one side those prior submissions, noting that we're seeking to be able to file further updated submissions ahead of a final hearing, does identify those behaviors or actions which are sought to be restrained.
Yes.
And does.
It doesn't identify.
Excuse me. And also does identify those further actions sought to be restrained in relation to the second defendant specifically. So, if necessary, and we will, can certainly identify things further in the written submissions, but, of course, S-447 of the Uniform Law, under which this application is made, does also provide for that basis. So that's the section of Court Book 7 is what is relied upon, and the amended originating motion makes clear the final relief that it sought in relation to the behaviors or actions which are sought to be restrained.
All right.
So if there are further matters that need to be particularized within the submissions, they can be, and if there's any further complaint by the defendants, then they can make that either in their submissions or later.
Thanks, Mr. McAuliffe. Now, Mr. Cooksall, back to you. One matter that I didn't raise with you, other than right at the beginning, was the protective costs order application that you have floated in the proposed summons.
Yes.
Is that something you want to deal with orally now, or is that something you want to?
Your Honor, that would require evidence to be filed because fundamentally what we're claiming is that these proceedings ought to be considered as if they were in the public interest to be litigated.
Just procedurally, again, so you say you want to make that application supported by evidence?
Yes.
It's unusual, is it not, to have a protective costs order made on the application of a defendant to a proceeding?
No, it's not. And also, it's our position, Your Honor, that the current proceeding was only instituted in retaliation to the other proceeding that we have.
So you want to put in some evidence in support of a protective costs order?
Yes, that's right.
When would you be able to get that evidence in?
If the court gives us leave, we can file some material in the next 2 weeks. And we may need to file further evidence based on the pending disclosure items in the other proceedings that we're expecting to be decided upon in the next.
So basically, you say you could put an affidavit and submission in 2 weeks?
Yes, but Your Honor, we will also rely on the material discovered through the subpoena.
All right, plus the subpoenas.
Yes.
So depending on what I do with that could delay the matters. You'll get leave to serve the subpoenas, then you'll want to reserve the right to add material to your protective costs order application from that.
That's right, and we want to issue another subpoena in relation to the protective costs order.
I'm not going to deal with that right now, Mr. Cooksall. I've got enough on the plate, I think, at the moment.
So what we wish to establish through the material that we're seeking to adduce in support of the application for a protective costs order is that the current proceeding constitutes an egregious violation of our constitutional rights. And it is misfeasance of a particularly egregious sort because the Legal Services Board is acting in contravention of the objectives of the Uniform Law and is in fact unlawfully abrogating legal privilege and encouraging the sort of behavior that it is supposed to regulate against.
You're not presenting the argument now, Mr. Cooksall.
No, but I'm just contextualizing why we need to issue subpoenas and file evidence in support of the protective costs order application. Also, Your Honor, I have said this previously, we put the LSB on notice and we advised the court that we would like to cross-examine any deponents of affidavits filed in the proceeding, and we are contending that Mr. Davidson's affidavit contains some portions which will lead to us raising allegations of him being sworn fraudulently.
Well, you'll put that in your outline of submission, no doubt, which is circulated prior to hearing. You've put him on notice that you will be wishing to cross-examine people. All right. I am going to reflect on the matters that have arisen, and I think I'll put something in writing. Mr. Cooksall, you said you wanted to put some cases in.
Yes, we emphasize that we want to raise an actual bias application, and unless the court decides it without hearing it.
I've listened to you for 45 minutes or so this morning.
Those were the grounds on which we can raise an actual bias application. But an actual bias application would involve the court deciding whether the allegations that we're making are tenable at law, firstly, and whether the harm that we're alleging or attributing to Your Honor's conduct has actually occurred, whether it gives rise to a basis in tort law to commence proceedings against Your Honor, and so on and so forth. So those matters will need to be particularly pleaded and then decided by the court in an actual bias application, because the actual bias is not.
Mr. Cooksall, so you're saying that at the moment, you're not making an actual bias application?
No, I am making an application for actual bias, but I'm saying.
Today?
Yes, that's what.
That's what I thought, but you're not in a position to present the argument.
What I'm saying is we should be given an opportunity. This hearing was not meant to be long enough for an actual bias application to be heard. So if the court does not accept our application on the time bias test, then the court should schedule a longer hearing so we can raise each of these issues in detail, and then the court.
If you wanted to bring an actual bias application.
I did bring one today.
Sorry?
Your Honor, I'm seeking to bring one today. So if the court wants to schedule.
But at the same time, you're saying, I thought you were presenting one orally. Are you saying?
But Your Honor, I wasn't given enough time, is what I'm saying. If I were to make an application for actual bias, I will need.
What would you need?
I would need at least 3 to 4 hours.
An affidavit?
I would need to rely on authorities.
But you would need affidavit material?
Yes.
And submissions?
Yes.
All right. I will reflect on that as well. So your position is, you have argued today apprehended an actual bias, but you say that you haven't fully developed the actual bias. I'm not persuaded by it so far. You want the opportunity to present your argument again on actual bias.
So what the authorities clarify is that.
Yes or no?
Not quite.
All right. In what way was my summary incorrect?
I have not argued actual bias because I've not been given an opportunity.
All right. So it's apprehended bias. All right. I understand.
Yes, but I've foreshadowed that if the court is not with us, then we must be heard about the actual bias.
All right, I'm going to reflect on that, Mr. Cooksall. I'll give you until midday, which, you said an hour, to put.
Yes, that's fine.
Cases on the bias application.
So can the court also please consider the affidavit of Ms. Zhu and.
I will have a look at it, assuming I can find it, but that's just to do with the apprehended bias, is it, Mr. Cooksall, presumably?
The other thing that it does is it puts into evidence material that was relied on in the recusal application that was heard on the 17th of May in relation to the LSB other proceeding, so.
I'll have a look at it. If it's something that I think is of consequence to me, I'll have to give Mr. McAuliffe leave to respond to it. I imagine his client hasn't seen it yet, has he?
Yes, but he's not taking a position in respect of.
But he hasn't read it. You're saying there's hundreds of pages of affidavit material that you want to rely on, without letting the other parties have a chance.
No, but he's not taking an objection in the other proceeding. He's already considered that in the other proceeding.
I'm talking about this proceeding, Mr. Cooksall. If there's something in Ms. Zhu's affidavit that causes me to think that it swings the balance or something like that, I'll probably have to get back and give Mr. McAuliffe an opportunity to respond.
That's fine, but we should be able to rely on that.
All right, I will endeavor to put something in writing, and I'll make some orders in relation to it. Depending on what I do, I'll make, then, procedural orders to get this matter moving further forward.
And Your Honor, in terms of the subpoenas.
So Mr. McAuliffe had estimated that trial would be 3 days. That's probably an appropriate estimate, isn't it, Mr. Cooksall?
Yes, Your Honor, but in terms of the subpoenas, can we get some clarity about what Your Honor proposes?
Yes, that's what I'm reflecting on as well. All right.
We issue more subpoenas.
Well, Mr. Cooksall, you say you're just going to issue more subpoenas. I'm dealing with 2 draft subpoenas that have been sent to me.
Your Honor, they were sent in February. Since then.
Well, I'm telling you I'm dealing with what I've got before me at the moment. All right.
But well, what where?
I'm not going to. What I'm going to do now, I'm not going to reconvene. What I'm going to do is, if I can, hopefully today, publish some reasons and some orders reflecting those reasons.
Okay, and Your Honor, in relation to the further conduct of the matter, if no, Your Honor could also consider the appropriate timeline for return of documents and so on, pursuant to subpoenas or any other subpoenas that we are intend to lodge. In the event that Your Honor does not recuse himself.